People are talking about a quiet but consequential doctrine: when and how courts and administrative bodies presume they have authority to act. The doctrine of rebuttable presumptions of jurisdiction holds that in many modern regulatory systems, a proceeding will proceed on an assumed jurisdictional basis unless a party timely and adequately challenges that assumption. That premise sits at the intersection of administrative design, statutory delegation, and litigants. Recent headlines have converged on that doctrine through a new Supreme Court slip opinion, Margolin v.'s National Association of Immigration Judges, which probes who may decide immigration disputes, how immigration judges are situated within the executive branch, and what courts should do when the architecture of adjudication is contested. In plain terms, the question is not merely whether an immigration judge issued an order, but whether the adjudicative structure that produced that order is properly vested with the public authority to do so. That inquiry reaches appointment and delegation instruments, the scope of 8 U.S.C. 1103a, implementing rules, and the Administrative Procedure Act's framework for review. It also brings into focus the practical consequence of presumptions. When a tribunal asserts authority and moves forward, what burden rests on the challenger to uproot that presumption? The answer is consequential for migrants, practitioners, the Department of Justice, and the judiciary that reviews administrative action. The paper trail begins with the primary decision now on CourtListener. Margolin v. National Association of Immigration Judges, Supreme Court slip opinion, CourtListener docket and opinion number referenced on CourtListener. Read the slip opinion and the full docket entries for the court's order list, briefs, and appended records. The underlying petition for certiorari and merits briefing in the Margolin docket are essential. The certiorari petition presents the threshold questions of delegated authority and structural review. The merits briefs argue competing interpretations of appointment and delegation regimes. For statutory grounding, consult the Administrative Procedure Act, especially 5 U.S.C. 551 and 701 to 706, which set basic definitions, exemptions, and standards for judicial review, and 8 U.S.C. 1103a, the Immigration and Nationality Act provision that authorizes the Attorney General's supervision of immigration administration. Administrative instruments are central. Relevant documents include the Department of Justice's and the Executive Office for Immigration Review's appointment instruments for immigration judges, any delegation memoranda by which authority is assigned to the Attorney General or to the EOIR, and the official organizational orders establishing immigration judges' duties and status. The administrative record in the underlying immigration cases, the agency's internal guidance and procedural rules, e.g., EOIR rules of practice, and any DOJ memoranda about the governance of immigration adjudication illuminate how authority has been exercised in practice. Doctrinal context is drawn from scholarship on presumptions and burdens. Consult the book, The Presumptions of Jurisdiction, How to Avoid Courts and Win When You Can't Avoid Them, particularly the chapters on burden of proof and rebuttable presumptions, which frames modern statutory and administrative proceedings as operating frequently on assumed consent unless interrupted. For historical and doctrinal background, a classic treatment is the University of Pennsylvania Law Review article on presumptions, c. 1920, which discusses the logic and allocation of burdens when fact patterns or legal entitlements are presumed until rebutted. Together, these primary sources form a trail by which one can assess what was asserted, what instruments support that assertion, and how courts historically allocated the burden of disputing jurisdiction. Public versus private analysis requires us to distinguish capacities, not merely actors. An immigration judge operating in public capacity exercises delegated sovereign power, adjudicating removability, ordering relief, affecting liberty and status. That public capacity carries constitutional and statutory constraints, appointment and delegation rules, due process link protections, and standards of judicial review under the APA and the INA. By contrast, private capacity would denote someone acting by contract or commercial relationship without sovereign authority. The stakes are high because if an adjudicator lacks proper public capacity, the acts attributed to them may be void or voidable, and affected persons lose public law protections that attach to lawful adjudication. Presumptions of jurisdiction function as procedural shortcuts. When an agency and its tribunals follow established forms, dockets set, notices issued, hearings held, courts and participants often treat jurisdiction as presumptively present. Practically, that presumption places an initial burden on challengers to present affirmative evidence or legal argument that the tribunal lacked authority. The book The Presumptions of Jurisdiction frames this as a structural feature of modern administrative governance. Agencies and their instruments move forward on assumed authority unless a litigant timely rebuts the premise. The law traditionally justifies that allocation by efficiency and stability. The danger is that reliance on presumptions can obscure fundamental defects in the delegation or appointment process. Margolin brings two intertwined doctrinal problems into relief. First, delegation and appointment. 8 U.S.C. 1103a vests supervisory authority in the Attorney General, but the manner in which authority has been delegated to immigration judges through internal DOJ instruments, statutes, and rules must conform to constitutional appointment principles and statutory constraints. Courts reviewing such delegations ask whether the grant of authority respects the separation of powers and appointment clauses, and whether the Attorney General's supervision is meaningful in practice. The presumption that delegations are valid until challenged places the onus on petitioners to identify precise statutory or constitutional infirmities. Second, judicial review and deference. The APA's judicial review provisions, 5 U.S.C. Decree 701-706, define the scope of court inquiry into agency action. If an immigration adjudication proceeds under an established regime, courts may be predisposed to treat the tribunal's authority as lawful absent a clear showing to the contrary. The slip opinion in Margolin contemplates whether appellate courts should parse agency governance on their own or defer until plainly presented. The question of who bears the burden to displace the presumption, administrative challengers or reviewing courts, shapes outcomes. The 1920 University of Pennsylvania Law Review piece on presumptions illuminates long-standing principles. Presumptions are rebuttable, and the allocation of evidentiary burden is ultimately a policy choice, balancing finality, reliance, and fairness. From a rights perspective, immigration adjudications implicate liberty, removal, and the right to an adjudicative process consistent with statute and constitution. When the presumption of jurisdiction persists unchallenged, individuals may lack the procedural foothold to require that adjudicators demonstrate proper authority. Conversely, mounting a challenge to jurisdiction is itself procedurally risky. Raising structural defects may foreclose merits consideration and, in some contexts, be procedurally defaulted. In evaluating Margolin, distinguish between a challenge to the merits of an immigration determination, e.g., removability or relief eligibility, and a structural challenge to the adjudicative framework. Remedies differ. Jurisdictional defects can render proceedings void or subject to vacature, while merits errors may trigger remand or rehearing. Finally, consider the practical interaction of presumptions with administrative logistics. Agencies routinely assign calendar blocks, reuse forms, and rely on long-standing personnel structures. These patterns create reliance interests among parties and the public. Courts weigh those interests against the principle that the public's authority must be properly bestowed. Margolin asks, when institutional convenience yields to constitutional and statutory mandates, and how the law's presumptive thrust should be distributed when adjudicative architecture itself is contested. The outcome will shape the burden of proof in future challenges and will recalibrate the line between tolerable procedural presumption and intolerable delegation gaps. Here are specific questions and documents to pursue if you want to dig deeper. 1. Read the full Margolin v. National Association of Immigration Judges slip opinion in the CourtListener docket entries, including the certiorari petition, merits briefs, and any appended administrative records. Track the dates and signatories on DOJ and EOIR appointment and delegation instruments cited in the briefs. 2. Study 8 U.S.C. 1103a. In conjunction with the Administrative Procedure Act, 5 U.S.C. 551, 701-706. How have courts interpreted the Attorney General's supervisory power in immigration contexts? Locate leading precedents addressing delegation to immigration judges. 3. Obtain the Department of Justice and EOIR memoranda, appointment orders, and delegation memoranda that specify immigration judges' duties and status. Compare their language to the Constitutional Appointment Clause and to statutory text. 4. Read the chapters on burden of proof and rebuttable presumptions in the Presumptions of Jurisdiction and the University of Pennsylvania Law Review article on presumptions, c. 1920, for doctrinal theory. How do those treatments allocate the burden of proof when a tribunal's authority is contested? 5. For context, pull recent appellate rulings that address structural challenges to administrative adjudication, including how courts have treated timely objections versus forfeiture. Note how remedies varied: dismissal, vacatur, remand, or plenary review. Each of these documents and questions will help you map the interplay of statutory text, administrative instruments, procedural posture, and the burdens required to displace presumptions of jurisdiction. We suggest verifying every citation against primary sources and thinking critically about the difference between a tribunal acting in public capacity and actions that amount to private or commercial.